and welcome to yet another episode of Legal Wrangle on International Taxation and Domestic Taxation. In this episode, we are presenting before you cases relating to applicability of withholding tax provisions in case of shipping business, taxability of compensation received by an Indian journalist from foreign publisher, application of CBDT circular to pending references, denial of DTAA benefit to assessee temporarily employed in the USA upon receipt of salary from the Indian entity, and chargeability of settlement amount received by non-residents against surrender of rights to sue. Today we start with a larger bench decision where the key issue is whether when the assessee declares its income and if the tax is deductible at source, the sum mentioned in Section 40A is to be reduced if there is a failure to deduct TDS under Section 195. The assessee is VS Dempo and Company Private Limited. Now let's go to Mona Lisa for details of the case.
The assessee company was engaged in the business of mining and export of processed iron ore. The assessee had charged demurrage charges paid to a non-resident under the head export expenses on which no tax was deducted. The assessing officer held that in view of Section 40A, read with Section 195, the amount paid as demurrage charges was liable for addition under Section 40A.
The larger bench concluded the matter by holding that there was an obligation to deduct the tax at source for payment made to a non-resident or a foreign company in terms of subsection 1 of Section 195. But in case of assessee, which is an exporting concern, the overriding provision in Section 172 in relation to shipping business will come to its assistance. Hence, the court favored the assessee and held that there was no obligation to deduct TDS in this case as the provisions of Section 172 are applicable to the assessee. In our second case, the key issue was whether compensation received by an Indian journalist from a foreign publisher is liable to be treated as capital receipt not chargeable to tax in case such compensation was an ex gratia payment upon termination of publishing contract. The present assessee Sharda Sinha is successor in interest of deceased assessee who was a journalist by profession and was appointed as foreign correspondent in India of a German news magazine. Now let's go to Mona Lisa for details of the case.
During period concerned, the publisher terminated the contract and paid compensation to the assessee for his long-term association and loss of workspace. In assessment, the compensation was treated as revenue receipt on the ground that the termination of contract did not mean that the assessee had lost his right of authorship in future for all publications. The Commissioner, however, on appeal, held the receipt of remuneration from such publisher was assessee's only source of income till the termination of contract. Further, the compensation was paid in consideration of his long-time association and as a gesture of goodwill. Hence, it deserved to be excluded from assessee's total income.
The High Court observed that the sum paid to the assessee was to compensate for abrupt loss of source of income and that the termination of contract had fatally injured the assessee's only source of income for the last 20 years. Therefore, the mere fact that assessee was free to earn through other sources would not change the character of receipt and hence will remain a capital receipt. In our third case, the key issue was whether CBDT circular restraining the revenue from filing appeal in High Court under Section 260A having tax effect of less than Rs 20 lakhs would also apply to pending references under Section 256. The assessee is Sunny Sounds Limited, engaged in business of dubbing sound recording. Now let's go to Mona Lisa for details of the case.
The ITAT having raised instant reference to the High Court at the instance of revenue, where admittedly the tax effect was less than Rs 20 lakh. It was inquired whether CBDT Circular number 21, 2015, dated 10th December 2015, would apply to pending reference made under Section 256(1). In response, the Revenues Council submitted that a bare reading of circular indicates that it applies only to pending appeals, as there was no mention of reference under Section 256(1).
The High Court observed that though references are undoubtedly made by the ITAT, they emanate from an application by one of the parties before it giving rise to the question of law requiring the opinion of the court. This in practice is similar to the statutory appeal under Section 260A being filed to the High Court. Thus, a pending appeal under Section 260A is no different from a pending reference. Resultantly, circular dated 10th December 2015 would be applicable even to pending references in the same manners they apply to pending appeals. In our second last case, the key issue is whether application of Article 16(1) of the Indo-USA DTAA can be denied to assessee merely because the salary check was paid by an Indian entity even when no service was rendered by the assessee for the concerned period in India. The assessee Neeraj Badaya was transferred for a period of 2 months from India to the USA. Let's go to Mona Lisa for details of the case.
During assessment, the AO held that exemption under Section 16(1) of Indo-US DTAA as claimed by assessee cannot be granted, as the salary was received through a credit of his salary account after deducting TDS. Thus, the same would be taxable in India irrespective of the assessee's residential status.
The ITAT observed that the applicability of Article 16(1) of Indo-US DTAA depends on the country where services are rendered, which in the instant case is the USA. And such application cannot be denied merely because the salary check was credited by an Indian entity. Relying on the judgment of Apex Court in case of Kedarnath Jute Manufacturing Company Limited versus CIT, wherein it was held that actual and legal nature of transaction would decide the taxability and not mere book entries, the ITAT concluded that assessee was not liable for tax in India on payments received from India. In our last case, the key issue is whether settlement amount received by a non-resident trustee on behalf of mutual fund investors for discharge of claims and suits against an Indian company can be treated as capital receipts not chargeable under Income Tax Act. The assessee Aberdeen Claims Administration Inc. is a listed US company which manages and advises certain investors that had invested in Satyam shares. Let's go to Mona Lisa for details of the case.
A number of foreign mutual funds had invested in the ADRs of Satyam and suffered losses following the disclosure the profits of the company were inflated. The class action suit filed by these investors was settled and compensation was given. The assessee representing the investors sought a ruling from the AARs as to the taxability of the amount in India.
The AAR noted that at the time of investments in the shares of Satyam, the assessee investors were registered as FIIs with the SEBI and they had not carried out any trade in securities. The AAR therefore held that the settlement amount received by such FIIs as per court's order is not a periodically monetary return but against surrender of right to sue and is not linked with the income generating apparatus, that is shares of Satyam. Hence the settlement amount has to be characterized as capital receipt, and once it is a capital receipt, it goes outside the scope of income chargeable to tax. Well, this brings us to the end of this episode of Legal Wrangle on direct and international tax. You may write to us your comments, criticism and counsel at editor@tioltube.com. Have a good day.